final case for this morning is Fisher versus State. Ms. Carey, you may proceed.
Thank you, Your Honor. May it please the Court, my name is Nada Carey, and I represent the appellant Andre Fisher, who was convicted of first-degree premeditated murder while carrying a firearm and was sentenced to death. I realize the Court is somewhat familiar with the facts of this case, having heard oral argument in the co-defendant Derek Cummings' case earlier this summer. However, I'd like to just briefly recap the facts as they're central to each of the three issues I'd like to address today.
Would you keep in mind also that it is sometimes difficult to separate out the facts of a co-defendant's case, and so would you make a special effort, if you can, with reference to facts that are established about the co-defendant related to the facts established about this defendant? So, for instance, in the other case, as I recall, there was rather specific proof as to the co-defendant acting on the report of this defendant being assaulted by the victim and securing a weapon and then going to the victim's residence. Rather direct evidence as to the co-defendant acting on that. So I'm particularly interested, as you relate the evidence that was submitted here, as to whether or not there was also direct evidence with reference to this defendant acting after that earlier incident and assault.
I understand your point, Your Honor, and I will try to do that. The evidence that was presented in Mr. Fisher's case briefly was as follows. At about 7:30 p.m. the night the shooting took place, Fisher got into a confrontation with a man named Dapp, someone he'd never met before. Dapp apparently shouted at Fisher, who was driving by the street, to turn on his lights. Fisher stopped, got out of the car, approached Dapp, said, "What's going on here?" An argument ensued. There was a crowd of people there. The upshot of the argument was that Dapp cracked Fisher on the head with a beer bottle. One of the witnesses persuaded Fisher to get back in his car and leave. Fisher did, and so did everyone else. The shooting took place about an hour and a half later, around 9 p.m., and what we know about that is that a car driven by one of the co-defendants, Marion King, was seen heading towards Dapp's sister's house. There were 4 people in the car. The only one that was identified was Andre Fisher, who was identified as being the front passenger. The car drove around the corner and shot up the sister's house where Dapp's car was parked in the carport. 35 bullets were fired into the carport area. About half of those bullets, based on the fragments that were found, went into the rear brick wall of the carport. Another half of the bullets went in or around the car, which was right in front of the brick wall.
Was there evidence that someone was in the carport that, quote, looked like Dapp?
Yes, sir, there was. Shortly before the shooting, the child that was killed, who was Dapp's nephew, his father was smoking a cigarette in the carport area, apparently on some steps right there in front of the door. His testimony was that as he went back inside the house, he saw some headlights approaching down the street. He didn't pay any attention to them. He went back in the house, closed the door, he walked through the kitchen and into the living room, and was about halfway across the living room when he heard what sounded like firecrackers, which were the bullets being fired into the carport.
And
one of which
Dapp's car was parked in the carport?
Yes, it was in the carport, pulled up right inside next to that brick wall. And as you know, one of the bullets struck the child who was asleep on the sofa.
And this was the car that Dapp was driving when there was a confrontation with Fisher?
No, Dapp had walked up to where the confrontation took place.
Okay.
His car...
It was the defendant that was in an automobile.
Yes, Mr. Fisher was in a car. Dapp was walking. He walked up to the corner store to get some beer, and that's where it took place.
Now, who did you say was identified as having been in the vehicle?
As in the vehicle?
Yeah.
Andre Fisher, my client.
Your client was identified
Yes.
as being in there.
Yes, a witness saw the car and said that was Andre Fisher.
Okay.
He also recognized the car as belonging to Marion King, one of the other co-defendants. Now, the other,
That was,
King testified?
no, King did not testify. There's just one other area that I wanted to get into that Justice Anstead, you talked about. And that was between the incident between Fisher and Dapp at 7:30 and the actual shooting. We know one thing, and that's some circumstances regarding Derek Cummings, the co-defendant. And what we know there is that he was with some friends or cousins when he got a phone call. This was probably around 8:15, and was told that Dapp jumped Andre. His response to that was to, after one of the other people he was with told him, well, Dapp carries a weapon and he's pulled a gun on me. Derek Cummings was driven by one of his friends to his apartment. He said, take me to get my gun. They went to his apartment, and he was seen, Derek and his friend, not a co-defendant, were in the neighborhood looking for Dapp immediately thereafter. The person that saw them, talked to them, said Cummings had an Uzi on his lap. He said, where's Dapp? The person they talked to said, he's not here, everybody's left. Why don't you leave too? And he left.
Okay, that proof was presented in this case.
That was presented to Mr. Fisher's jury as well.
Okay, tell us what the proof was, the evidence was that was presented. You've mentioned about the identification of your client by a witness, that your client was in the front passenger seat of the vehicle as it approached the house in question. Is that correct?
That's correct.
All right. Now, what about the identification of the other people in the automobile and the proof with reference to the weapons involved, and then the proof with reference to, what weapons were fired at the house caused the death, but what weapons were fired at the house and their connection to your client?
Okay, let me start with the weapons. The ballistics test showed that 3 weapons were used. There were 4 people in the car, but only 3 weapons were used. Therefore, presumably, only 3 persons in the car were shooters.
but weren't 2 of those weapons connected to Cummings?
Yes, the 2 of the weapons, the Uzi and a Glock, were linked to Cummings. The day after the shooting, a Glock with his fingerprints was found in his apartment. The bullet fragments that were found were said to be consistent with a Glock, consistent with an Uzi, and the others were consistent with a Tech 9. Now, that gun was linked to the driver of the car, Marion King.
How do we know that King was the driver? Because it's his car?
It was his car, and what happened is four boys or 4 young men were originally charged with second-degree murder in the case. Cummings, Fisher, King, and another man, Kevin Dixon. King turned state's witness. He agreed to testify against the others in exchange for second-degree murder charge against him. And what happened, though, is the day before trial, Kevin Dixon's lawyer presented evidence that King had lied. He had told the state that his gun wasn't used, he didn't carry a gun, and he wasn't a shooter. Well, his gun was positively matched to some of the shell casings that were found in the street. So realizing that they couldn't use King anymore, the state had to null pros the charges against Kevin Dixon because King's testimony was the only testimony placing him at the scene. They also decided they couldn't use King as a witness because his credibility had been so damaged. They couldn't vouch for his testimony. So they went against the other 2, Cummings and Fisher, without Marion King's testimony.
Well, we've talked already about the pretty specific evidence against Cummings. He's got the Uzi in his lap. He's connected to another of the weapons. And we know the tests that were done, the shell casings that were found later, and you know, the bullet fragments, and his statements, and you know, the evidence there. I'm interested more now, but this is this case. So tell us what the proof was connecting your defendant to a weapon and the shooting.
There was no proof connecting Fisher to a weapon at all. He was never linked with any weapon. There was no evidence he owned a weapon, used a weapon, that he did anything other than sit in the car at the time. There was no evidence that he was a shooter. There's no evidence as to when he met up with Cummings and the other three and headed over to the neighborhood. There's no evidence of any
testimony or evidence
There's no
putting
testimony.
him in possession of one of the weapons that was used?
No, Your Honor, none whatsoever. There's no testimony of any conversations between Fisher and any of the other three.
Which direction was the car coming? Do you understand what I'm asking?
Yes, I do.
If he was a passenger, was he on the side next to the house or opposite the house?
That question is not conclusively answered. The car was going down the street, and on the right side of the road at the corner would be the house. It was on the corner. The car turned right, so that if the shooting occurred right then, Cummings would have been on the side facing the carport. There was some evidence, however, at least in the prosecutor's argument and elsewhere in the record, that the car may have circled around and come back. So we don't really know exactly where the car was. No one testified about seeing the car in front of the house. There was a witness who saw the car make the turn.
Not sure I followed it. The car passed houses on the corner, is that the idea?
Yes, it passed the house on the corner.
So he's coming down past the house and turns right?
Yes, placing the car in front of the side of the house where the carport was. Okay, the carport was on, I can't remember the name of the street, Dostie, but the car, so we don't know. Somebody saw him make a turn where they would be in front of the carport. The shooting.
You mean to turn in?
No, not to turn in, to turn onto the street that the carport faced.
Made a wide right turn.
Yes.
But the point is that just before they made that wide right turn, there was testimony that put Fisher in the passenger side of the vehicle.
They drove by somebody at the top of the street who saw four people. He said Fisher
And
was.
he identified Fisher as being in the passenger side of the car.
That's correct.
And we know that in the drive-by shooting, that 3 weapons were used to fire 35 shells into the building, correct?
That's right, into the carport.
So that it's basically that within a very short period of time, from the time that Fisher was seen in the passenger side of the car, that shots were fired from the car with 3 weapons.
That's correct, Your Honor. We don't know who fired those weapons. As I said, 2 of them were linked to Cummings and the other one to Marion King.
What is the most you believe that the defendant could be found guilty of under this evidence?
Your Honor, I think the evidence shows at most that he was present at the scene. I think the state.
And that is a felony or a misdemeanor?
I don't think it's a crime at all.
So you think he is not guilty of any crime?
That's correct, Your Honor.
Under the evidence in this case?
He was in the car. We have no idea even what Derek Cummings planned. We know Derek intended to he intended to confront Dapp He took guns with him. They all had guns. But we have no idea what any of these four people intended, if they intended anything other than a confrontation of some kind.
Well, but we do know that the car that was driven by King went by the house. Now, in going by the house, was the passenger side closest to the house in the carport?
We don't know, Your Honor. As I
Don't we know
explained,
the direction the car was going?
we don't know where the car was when the bullets were fired. We know that it turned right in front of the house, but whether it went by the house and came back around, there is some evidence that it came back around before the bullets were fired. So we don't know.
If it turned right, the passenger, as I understood what I read, the passenger side of the vehicle would be closest to the carport.
Yes, if the
correct?
bullets were fired at that point. That's correct, Your Honor.
And so that when it made the wide right turn, that put the passenger side of the car closest to the carport.
Yes, if the bullets had been fired at that point in time.
I
That's
mean, do you
correct.
agree that an inference could be drawn that the person sitting in the front right passenger seat fired some of the shots
That's,
because the car was faced? Would you agree that that inference could be drawn from that?
I would
proof?
have to agree that that's one of the inferences that could be drawn. Another inference that could be drawn would be that the three other people fired the shots.
Well, I mean, this is an important factor with reference to this. On the one hand, you say you agree that the inference could be drawn, but you're saying that another reasonable inference is that any of the other people could have fired the weapons.
The
I
point,
take it you're saying that that's not sufficient proof.
that's correct, Your Honor. The point I'm making is that that inference could not be drawn beyond any reasonable doubt. It's just as likely that the other three persons fired the bullets.
Well, we know that Dapp hit Fisher on the head with a bottle.
That's correct.
And do we know that who called Cummings?
We don't know that either. Cummings was beeped. He made a phone call back.
To whom?
He talked to someone. The evidence does not show who he talked to.
But-
There were several people with him. They observed, this testimony came out, they observed that he made a phone call. He hung the phone up. He said, Andre got jumped by Dapp. Didn't say who he talked to.
Okay.
He could have talked to Fisher. He could have talked to Kevin Dixon. He could have talked to Marion King. We really don't know.
But the evidence is that he went then to get his guns to go get Dapp.
Yes.
And when do we know that Fisher picked up with Cummings?
The earliest we see Fisher again is just a few minutes before the shooting took place
Okay.
in the car.
And it's your position that it is not a reasonable inference to assume under those circumstances that Andre Fisher was a part of this incident?
He was a part of the incident, but that's a far cry from saying he was a part or a participant in what actually occurred. How can we look inside any of these four young men's minds and discern what they were planning or what they intended other than that they were seeking out Dapp? Maybe somebody in the car said, I'm going to scare the heck out of him. We just don't know.
Well, but there is evidence that a guy that looked like Dapp's brother, is that right?
Yes, his
Was out in the
brother-in-law.
carport smoking a cigarette. He saw the headlights of this car from which the bullets ultimately came. And he went in to the door that they used to fire all of these bullets, the target of which these bullets were mostly around. And what are we to draw from that?
Well, a couple of things, Your Honor. Mr. Lucas was in the living room when the shots were fired.
Right.
We have no idea whether anybody in the car saw him. The testimony was that the carport was dark. There were bushes obscuring the view from the car to where he was standing in there in the dark carport. He testified himself that he didn't know if anybody could see him at night from where he was standing. He was also obscured by DAP's car, which was right in front of him, that came up about so high. He was already in the living room. We don't know if anyone saw him, but furthermore, even if they did, he wasn't there when the bullets were fired.
But he was
If
there.
they saw
He
him,
was there
Daps
immediately.
at home, let's get his car.
You seem to be suggesting, in addition to presenting your client's case, that there's not even a case against Cummings. I'm having difficulty with that when we have Cummings being reported as, in essence, saying, well, I'm going to go get revenge on DAP based on what he did, to your client, and furthermore, I need my gun to do it. And then proceeding there and, firing the weapons at the place where they believe DAP was located.
Okay.
Now, realizing there may be distinctions between the two cases, is that what you're suggesting?
Actually, Your Honor, there was no evidence that Cummings said anything either.
That Cummings said anything?
That's correct.
I thought
This is what Cummings
the evidence
said.
was that he got the report.
He got the report and he said, take me to get my gun.
Well,
That's all we know about what Cummings said. He ran into this witness in the neighborhood. He said, where is everybody? Where's DAP? That's all we know about what Cummings said. He never spoke any words of revenge either. No one did.
Take me to get my gun after having it immediately reported to you?
And after someone else in the room said to him, DAP carries a gun, and he pulled one on me. Protection.
In any case, we're here about your client.
That's right.
Okay, not
And our argument, Your Honor, is that his presence at the scene is the only thing the state proved as far as he's concerned.
Well, how about the other chains in this? And that is that the fact that it was your client that was assaulted by the apparent intended victim in this case. That is, that it was your client that was administered the striking over the head with the beer bottle or whatever, and that was at the root, apparently, of this thing. And then with your client being present, not only being present, but in that front passenger seat, if you put all those circumstances together, why isn't that a case of your client being part of in essence, a conspiracy to go get revenge on DAP, and that this terrible tragedy happened as a direct consequence of that effort?
Your Honor, I understand that the evidence, from the evidence, one could speculate that there was a conspiracy, but there was no evidence of a conspiracy. There's no evidence of what anyone planned. Mr. Fisher,
Is there any evidence to show that Mr. Fisher knew there were guns in the car?
no.
Was there any evidence to show that he knew they were going to go to DAP's house?
No.
Well, isn't there evidence of that?
There's no evidence.
Are you saying that there's no evidence? He's the passenger in the car. Okay, I assume the testimony is not that he was blindfolded, and that all of these weapons are fired from that car, and that the car, coincidentally, happens to be at the house where DAP's car is parked. I mean, you're saying that doesn't constitute evidence that your client knew that there were weapons there?
There is no evidence that he knew there were weapons.
Well, let me ask you this, after the fact, after the incident, Cummings and Fisher went to Cummings' girlfriend's house, correct?
That's right.
And that they were interested in looking at the nude that night. They got there at about 10? they wanted to watch the news at 11 as to what had happened.
They watched the news, and the girlfriend
That-
testified that Andre Fisher was shocked when he heard the child had been killed in the shooting. Cummings was apparently in another room at the time.
And and Fisher, your client had also written a note to her to tell the detectives when they were investigating that he was with her the entire time and at the time of the
Yes,
shooting.
the next day he asked her to give an alibi. He did.
And
We're
that-
not disputing that he was in the
and-
car.
Well, and also at that particular time and afterwards, that one of the weapons was found at the girlfriend's house
That's right. The
with
Glock
Cummings' fingerprints on it.
with Cummings' fingerprints.
And this all was discovered basically within 12 hours after the incident occurred,
That's correct.
together with the note from your client. But it was your client accompanied Cummings to that house.
They both went to the girlfriend's house afterwards, yes.
All right, Ms. Carey, you're into your rebuttal time.
Okay, I'll sit down. Thank you, Your Honor.
May it please the court, I'm Curtis French, representing the state of Florida. I would like to just start by pointing out that in my opponent's reply brief, she states on page 4 that Fisher has never characterized his role as that of an innocent bystander, and she concedes that the evidence shows that Fisher intended or is willing to retaliate against Dapp. I'd like to just talk about the evidence, the chronological story about how this happened. This began at 7:30 p.m. On a February night. Fisher was driving with no lights past Popeye's restaurant on Soodle, and he was driving too fast. Dapp hollered at him to turn on his lights. Fisher came back, the testimony shows, and started the fight. He was not assaulted. He started the fight himself. As it turned out, he got the worst end of the deal, and he got conked on the head in a beer bottle. Nevertheless, he had to be forced to leave. There were some other people that came over and assisted and broke them up. Shortly after that, we don't know exactly when, but certainly it was within an hour and a half, because the shooting occurred an hour and a half later. Someone called Fisher's nephew, Derek Cummings, and reported this fight. At that point, Cummings asked somebody to take him to get his gun. They went looking for Dapp. The next thing we know is somewhere about 9 o'clock, a car belonging to Marion King was driving down Washington Estates Drive. There's a diagram attached to the appellant's brief, which is kind of helpful to picture this, but Soodle runs parallel to Dostie, and Washington Estates Drive connects them. So Jason Robinson, who observed the fight, observed Marion King's car heading down Washington Estates Drive after he had also earlier observed Derek Cummings looking for Dapp. He tried to stop him. They drove on by. Fisher was in the front seat of the car. Fisher was 2 years older than Derek Cummings. Derek Cummings was in the back seat of the car. There were 3 9mm weapons in the car. A person resembling Dapp was at the Lucas house on Washington Estates Drive. It's Shelton Lucas Sr., who did not live there, but he was staying there that day with his wife and his 3 children. He had eaten dinner with him. Smoked a cigarette after dinner. Just as he was finishing smoking a cigarette, he saw the headlights of a car on Dostie Drive right in front of the driveway of the neighbor across the street. He went inside the house immediately, took a few steps into the living room, and the shots came into the house.
Dapp's automobile was parked in the driveway.
That's correct.
Is there any evidence here that the group in the automobile where the shots came from knew Dapp's car, or how this circumstance came about? They knew where Dapp was.
Dapp,
Somebody report to them?
Depp testified that his car was identifiable by certain things. I don't remember exactly what. And his car was sitting in the carport. He was known to, he stayed at that house 45 days a week. Depp was the sister of Charles E. Lucas, who was the mother of the victim. Depp was the brother of Charles E. Lucas, who's the mother of the victim. He had been there earlier that evening and had left, so he was not there. However, Shelton Lucas Sr. was about the same height, same build, and was dressed the same and was in the carport at that time.
Dapp had left, but he had left his vehicle.
His car was there. I don't think his car was running, I'm not sure.
Now, help me, I must say that we've had argument in the Cummings case, and the testimony that we've already gone over extensively about Cummings being connected to the weapons, Cummings making the statements about going to get the, I don't know if it was take me to get my gun or take me to get my piece or whatever the.
Well, it was.
That everybody understood, you know, what he was talking about.
It was a euphemism.
And then he's got the using in his lap at some point. All of that evidence about Cummings. But help me with whether or not the same case exists against this defendant that exists against Cummings, assuming there's a case.
Well, it's not exactly the same case.
Well, I'm having difficulty, though, without direct proof about who had the weapons and who fired from the automobile, whether this is a sufficient case against this defendant. For instance, no one knows, absent the pretty direct proof against Cummings, who fired the weapons from that automobile. For instance, whether Cummings, being identified with two weapons, fired both of those weapons, or whether the three other people in the car, besides this defendant, fired the three weapons. And why isn't that just as reasonable an inference as it is for Fisher to have fired one of the weapons? You have to help me with that.
Several circumstances. First of all, the reason this whole thing happened is because of Fisher. Fisher started the fight, and Fisher was hit on the head. Fisher
that doesn't prove that Fisher had a weapon. In other words,
not by itself.
He could be sitting there. In other words, he could have been sitting somewhere else in the car, still have been the victim, or whatever among these here. That doesn't prove that he had a weapon or fired one of the weapons, does it?
Well, there were three weapons in the car. There were four people. Now, actually, there was one shell out of the scene that didn't match any of those three weapons. Whether or not there was a possibility, at least, that there was a fourth weapon.
We don't know.
But ours.
Who fired the weapons?
Not for sure, no.
So why isn't it just as reasonable an inference that one of the other people in the automobile, other than Fisher, fired the weapons than Fisher?
Well, the state pointed out in its brief that even if Fisher did not himself fire one of the weapons, he aided and abetted this premeditated murder, and he's guilty on that basis.
How did he aid and abet if he's just sitting in the passenger seat?
Well, he's in the front passenger seat. I mean, Derek Cummings, who we know is one of the shooters, his nephew, who was 2 years younger than him, was sitting in the back seat. That's at least some indication that Fisher was not an innocent bystander, that he was a part of this, that he was, in fact, leading this.
There's no evidence that he was leading this, was there? That is, as opposed to the statements that we have proof of about Cummings.
There's no evidence of what?
That he was leading this. That is, where's the proof here, for instance, like the proof in Cummings' case, that Fisher said, let me go get my gun because I'm going to go get Dapp after he hit me over the head.
Cummings said that.
No, I know Cummings said it.
Right.
That's what I'm saying. Fisher, there's no evidence that Fisher made statements like that, is there?
We do not have direct evidence that he made statements like that, no, sir. We don't have testimony about what he said or didn't say. We know there was a phone call immediately after the fight in which somebody called Cummings and reported this fight. The fact is, Kevin Dixon and Marion King were not at the scene of the fight. The only one that we know of that knew Cummings that would have known anything about the fight was Andre Fisher himself.
Where does the evidence come from that that Cummings had the Uzi on his lap?
That was Jason Robinson. Jason Robinson was at the scene of the original fight. As a matter of fact, I think he helped break it up. Cummings drove by sometime thereafter with somebody else whose name I don't recall, in that person's car, and was asking, "Where's Dap?" And he had an Uzi in his lap.
Mr. French, there's no evidence here that Fisher had, no direct evidence that Fisher had a firearm.
That's correct.
But the jury found him guilty of that.
That's correct. The state argued that he was one of the shooters, and even if he wasn't, he was guilty as a party to the crime because he aided and abetted it.
Now,
Pointed out that Fisher was the one that had the motive. He was the one who started the original confrontation with Dap. This whole crime was committed in revenge of that altercation. And that Fisher definitely was there in the front seat of that car.
And even if if he is guilty because of he's an aider and abettor, he can be guilty even though of having a firearm, possessing a firearm, even if he did not.
That's correct. As a matter of fact, in a recent death penalty case this court decided not too many months ago, there were two co-defendants, Hartley and Farrell. Hartley was the trigger man who had the gun. Farrell was not the trigger man. This court affirmed his conviction for murder and affirmed the death sentence.
But did they do it, was it with a firearm?
It was with a firearm, yes, sir.
Okay. Let me ask you, where the evidence of, as regards to Fisher, of heightened premeditation to justify the CCP comes in, and I also want to talk about the great risk to many people.
Okay, it was heightened premeditation because this thing began at 7:30 and the revenge didn't occur until an hour and a half later, and that's plenty of time to form heightened premeditation. The premeditation is shown because...
Well, granted, there was time to do it, but what is the evidence that he was the one who had the heightened premeditation? I can see your point about being a part of it and following Cummings and going to the house. But what is does there have to be any evidence that he had a heightened premeditation?
I think the evidence has to show that the crime was premeditated and he was a party to the crime and had the same mental state as the others.
Well, but for an aggravator of CCP, don't you have to show more than that?
Heightened premeditation, yes, sir. Our position on premeditation is that it's shown by their conduct in firing 35 rounds at somebody. Well, they didn't wait for any kind of confrontation. They didn't go up to the person they thought was Dap on the carport and confront him and ask for an apology or explanation or anything. And they didn't wait for him to reach for a weapon. They saw him sitting in the carport. They parked the car. He walked in the door and virtually immediately began shooting at that door. 35 rounds. And that is just an indication of why they came there and what they were doing there. The fact that they didn't wait, but they simply fired 35 rounds at this retreating figure in this door.
Okay, now tell me what is the evidence about the number of people actually in the house at the time of this shooting?
All right.
I know there's some evidence about the number of people who lived there, but is there any evidence? What is the evidence about the number of people actually present?
All right. Shelton Lucas Sr. testified that he was staying at that house that day. He testified that his wife was there and his 3 children were there. One was age 10, one was age 7, and of course the victim was age 5. He testified that he ate dinner with his wife and his children, and this occurred sometime after dinner. He watched TV for a brief period of time, smoked a cigarette, and there's no evidence that any of those people left the house.
Okay, and is it your position, the position of the state, that these people did not have to be in the area where the child was killed?
Well, they certainly had to be in the line of fire, and of course the question is, what's the line of fire? Our position is that there were a total of 5 people in the house. We know that 3 of them were in this living room where the victim was. I mean, there's the victim's mother, and the victim's father. The other 2 children, we don't know where in the house they were.
All right, now, and my question is, can we just jump that they are among the people to whom a great risk was involved if there's no evidence as to where they were?
Yes, sir, because our position is because the shooting came from outside the house, from 60 feet away, and they were shooting at the house, that everyone in the house was in the line of fire. And
Does the defendant have to know that he's creating that risk, or is that just an after the fact?
well, our position would be that when you shoot into an occupied dwelling in a residential area at 9 o'clock at night, that you have some knowledge that there are going to be people in that house. I doubt they knew exactly how many people were in the house.
My question is a legal one. In other words, does the aggravator require that you knowingly create the great risk, or is it just that?
Yes.
It does.
It does require that you knowingly create a great risk to, I don't think it requires that you know exactly how many people you're creating a great risk to. You know, if they don't
Well,
get
we have sort of put a number on that, have we not?
4 persons besides the victim. That's most recently, I think, in one of the Carroll Johnson cases.
Well, if you have to know that, how is the proof here that the defendant knew there were 4 more people besides the victim?
I don't think he did. But our position is that he fired into an occupied dwelling at night, and if that occupied dwelling contained the requisite number of people, that's enough.
All right, excuse me, I want to go to another point when you...
Okay, I just want to briefly talk about this Johnson case, which is 22 Florida Law Weekly at S-259, in which the defendant sprayed up the store, and to me that's kind of similar circumstances. There he sprayed up a store, and here they sprayed up a house. There were people in that house, and there were enough people in that house to satisfy the great risk aggravator requirements.
The judge refused to give any instruction on a felony murder in this case, isn't that correct?
At the guilt phase, yes.
In the guilt phase. But yet in his sentencing order, he found that as an aggravator, that it was committed during the course of a felony, and the burglary is the entering of the bullet into the house.
That's correct.
Is that inconsistent, or is that appropriate?
He did charge the felony murder aggravator to the jury at the penalty phase, and what happened was after the jury found the defendants guilty of premeditated murder, i.e. that they intended to kill someone inside the house, the state asked the court to reconsider its position on felony murder and stated that since it was now clear that the entry by the bullets was with the intent on the part of the defendants to kill, that now clearly satisfied the requirements of burglary by instrument.
There was an interrogatory type verdict?
No, sir. At the guilt phase of the trial, the case was submitted only on a premeditated murder theory. At the penalty phase, the state asked for instruction on burglary as a statutory aggravator, and after some discussion, the judge agreed to do that and did so. And then ultimately, the trial judge did it.
So at the guilt phase, the case was limited to
That's correct. Premeditated murder at the guilt phase. And the jury found that the murder was premeditated.
Let me ask you this, no matter where as the factual circumstances were, the shots were fired when the car was on Dotsey Drive, not Washington Estates, were they not?
That's correct. The front of the house faces Washington Estates. Washington Estates Drive, dead ends at Dotsey.
The carport driveway is on Dotsey Drive.
That's correct. It faces Dotsey.
And how was that established?
Well, by testimony.
By testimony of who?
Several people, actually, and you have to go through and I've cited in my brief and pull out these various things to get that the house is facing Washington Estates and the carport faces Dotsey Drive.
But I mean, several people testified that the car was in a particular position?
Oh, no.
The shots, well, that's what I'm trying to... how was the proof established that the car was in a particular position?
Well, a couple of things, really. First of all, Jason Robinson saw the car as it was driving up Washington Estates. He saw the car made a wide right, start to go left and make a wide right. Very soon after that, he heard the shots. What shows the location of the car, in addition to that, is the location of the shells in that area.
And where were the shells?
Well, they were out on the street on Dostie Drive, right in front of the house. Presumably right where the car stopped, unless they drove half a block down the street and ran back.
In the middle of the street or over on the edge or where?
I'm not sure I can tell you exactly. It was in the street. None of the shells were on the Lucas property. They were all in the street.
I'm trying to establish what that would show. That is that, for instance, if the further the shells are over towards the other side of the street or in the middle, I assume might show that the firing was coming from the left side of the car, not the right side of the car. If the firing was coming from the right side of the car, the closer to the edge of the road, I presume they would be to the right. Is that correct?
That's certainly possible, but I went down and looked at the exhibits, and that particular issue hadn't occurred to me. I don't think there's any real dispute about the location of the car. It was in the street in front of the house.
In the street, but we don't know where it was facing.
Well, circumstantially we do, simply because of the time constraints here, because Shelton Lucas Sr. saw the car, coming up Washington, and he saw it turn on Dostie. He saw it right in front of the driveway of his neighbor's house across the street, and it was coming towards him as he walked in the door. Well, from his walking into the door to the living room is just a few steps, because you've got a couple, 3 steps in the kitchen, then another 2 or 3 in the living room, and you're right in front of the couch, and that's when the bullets came in. So if you look at the amount of time, there simply wasn't really any time for the car to have gone down the street and turned around and come back. By the time you got the car coming around the corner and it stops and they get out, there's your time right there. So, now, if you look at the exhibits, they might provide further corroboration of that. I'm not sure.
Yes.
And the location of the bullets, we would contend, illustrates the intent to kill the person that just went through the door, because the car was sitting in the carport, just hit just a couple, 3, 4, 5 times.
Let me ask you this,
Okay.
if I can, the bullet that killed the victim, is the trajectory through the door and then through the wall of the kitchen and into the living room where the victim was on the couch?
The trajectory is through the door. There's some testimony that there may have been a ricochet, whether it went through a wall, and I don't recall any testimony that went through a wall, but what it may have ricocheted against, I don't know. If you look at the photographs, if you're looking from the street through the kitchen door on this back brick wall, and you open that door up, you can see right into the living room, you can see the couch on which the victim was lying, so it's pretty much a direct shot.
All right, well, the diagram in there shows a kitchen in there. Is there an open wall from that?
There, as I recall, there's a
From
doorway.
the door into the living room then?
This diagram is essentially correct, except for the interior of the house doesn't show any bedrooms, so I don't know what the front 2 rooms are. But I've seen the pictures, and there's a small kitchen there. There's a doorway a fairly wide doorway in the living room. From outside the house, you can see into the living room, you can see the couch, you can see the big TV in the room. Most of the bullets were around or into the doorway, so our position is they were shooting at the door at the person that had just entered the door. I would just point out also that Shelton Lucas testified that the view from the street into the carport was not obscured, that there were some low bushes on the wall of the car. There was a very low wall to the carport on the side facing Washington Estates. There were some bushes there that you could see from the carport to Washington Estates Drive, and of course you could also see out to Dostie Drive, and that his view was not obscured. He testified also that the carport light, the overhead carport light, was out, but that there were other lights on all throughout the house, including the kitchen and the living room and so forth, and that there were windows.
Was there glass in that door going into the...
There was a Venetian blind inside the glass.
The whole door glass or the top of it, or?
There was a glass
Okay.
in the door that didn't go all the way down.
In an oval shape, like.
Well, it was rectangular, I guess. All right, if there are no further questions, I'll just rely on my brief as to anything else. Thank you.
I'd like to just briefly address the evidence against Andre Fisher as to the role he played and whether he was the instigator of what happened. After the fight that occurred, Fisher didn't strike back. He didn't threaten Dapp. He was, the testimony was that he was standing there saying, "What'd you do that for? What'd you do that for?" He didn't want to leave. And Jason Robinson had to persuade him to get in his car to leave, but there weren't any threats. And we don't know anything else about Andre Fisher until we see him in the car shortly before the shooting occurred. The great risk aggravator, unless we have different records, there's nothing in my record placing the other two children in the house. Mrs. Lucas testified that she had two other children who lived with her. I don't recall, and I searched for any testimony about eating dinner with the children or them being there in the house. We certainly don't know if they were there, where they were.
What do you view the record as? How many people were in the house at the time of the shooting?
The evidence, the testimony was that the mother, the father, and the child were there. That's all we have. So I don't think there's any question that aggravator doesn't apply. Going to heightened premeditation, again, looking at Andre Fisher, all we know is he was in the car when the shooting occurred. And it's our position, Your Honor, that shooting bullets, the bullets were fired from the street. The shell casings were scattered in the street, and I don't recall where they were, but there is a diagram as to where each shell casing was found in the record. Either the three or one or two of them got out of the car and fired the bullets, or some fired from the car. But I don't think that in itself, even if Fisher could be linked with the intent that the shooters had, is enough to establish premeditated murder or intent to kill someone inside the house. They were firing into a carport. There was no one in the carport, clearly, when the bullets were fired.
You fire into the carport, but you fire right into the door into the house.
There was a door into the house. Only 4 bullets even
and
touched.
that's where all the bullets were concentrated.
No, there were only 4 bullets that touched the door or the door frame. The majority of bullets went into the brick wall or into or around the car that was located in the carport. The bullets were fired randomly. This wasn't careful aim taken at the door to hit somebody that was behind the door. There was no one.
If you know, what was the numerical distribution? Was it 35?
There were 35 bullet fragments.
And where? Can you break that up into a numerical distribution?
16 fragments were found in or around the brick wall. 15 fragments were found in or around the car. I believe some of those, maybe 3 of them, were found on that far left wall, which was a utility shed. 5 or 6 hit the car, and the others were in or around the car. 4 bullets actually penetrated the door. 1 went into a utility room, 1 in the dining room, and apparently 2 went into the living room. The fragment that Mr. French referred to that couldn't be matched to any of the weapons couldn't be matched to any weapon ever because it was too small. I don't think it indicates there was any 4th weapon there. The bullet fragments actually came from only 2 of the weapons, the Uzi and the Glock. 3 of the shell casings were linked to the other gun, the Tech-9, but none of the bullets apparently from that gun went into the carport. If the court has no other questions, thank you, Your Honor.
All right, thank you. The court will be in recess till tomorrow morning.
Please rise.